Thank you for joining us this morning. Today, we're going to talk through the new laws coming January 1st, 2024, and what that means for your company. If you've listened to our webinars in the past, you know that I'm Sophie Dietrich. I am the HR professional for the Compliance Center team here at Wagner, Felkner, and Judd. Our team is dedicated to supporting you all as business leaders while you navigate the human resource and employment law world, and we're thrilled that you joined us today. So some quick housekeeping items before we get started. We're likely not going to have time for a Q&A today because we have a lot to cover. So please send us a ticket at the end of the webinar if your question was not answered, and one of our team members will look into it and get in touch with you. Also, so you are aware, this webinar is being recorded to share with those who could not attend live with us. So with those items covered, let me introduce you to our presenter, George Hiller. George is one of our employment law attorneys on the Compliance Center team here at WFJ. He dedicates much of his practice to counseling business leaders on maintaining compliance with all of the federal, state, and local laws. And we're very excited to have him share with us today. So thank you again, everyone, for joining us. And with that, I'll hand things over to George.
Thanks, Sophie. Hi, everybody. Welcome to the 2024 law update for the laws going into effect January 1. Some of the laws that we're going to be covering today may be going into effect a little bit later, sometime in the first quarter, but for the most part, it's going to be January 1. We do have a lot of material to cover, as Sophie mentioned. That said, I did my best to compile everything I could with laws going into effect in January, but I may have missed one or two. If there's one or two that you have questions about that I don't cover and you want to talk about them, you can always submit a ticket and we can address them. I am an attorney barred in both Minnesota and Florida, but we're going to be talking about all 50 states today. And let's jump right into it. Give me 1 second here. I want to make sure this is working. There we go. The first state we're going to visit is Arkansas. Arkansas passed two statutes this year going into effect in January. First is House Bill 1197, which allows prospective employers to notify the Division of Workforce Services if a candidate fails to appear for an interview or respond to an offer. This impacts that particular employee's or potential employee's ability to recover or collect unemployment. So it's not so much a big issue for you as an employer, but it is something to be aware of. Senate Bill 434 reduces the threshold number of employees from 250 to 125 for electronic tax withholding statements. So if you're over that 125 employee threshold, you have a new process for tax withholding. Now, California is going to be our biggest state in the presentation today. If you're not a California employer, it's probably a bit of a sigh of relief. You can sit back and just relax. If you are a California employer, we've got a lot to cover and a lot to do in the new year, starting with the Senate bill that creates a private right of action for employees against any employer that enters or tries to enforce a restrictive covenant which is void under California law, regardless of where the covenant was entered into or where they worked. It goes into effect January 1st. This is a pretty big deal because if you have, let's say, employees in Minnesota who signed non-compete agreements prior to the ban here in Minnesota in July, and they move to California, start working in the same field and potentially violate that non-compete, California will not enforce it for you. So good things to be aware of. The trend nationally, just so you're aware, is to have non-competes go by the wayside. States are banning them left and right at this point, and it's best practice for employers to start implementing other tools that can achieve some of the protections that they're looking for, like confidentiality agreements or non-solicitation agreements. Moving along to Bill AB 1228, specific for fast food workers, it raises the minimum wage for fast food national chains to $20 an hour and creates a fast food council. It also repeals some prior law, some things that no longer apply to you. That said, if you own a fast food chain in California, the minimum wage requirement for your workers has changed. California Senate Bill 616 is signed. It expands the paid sick leave law for California. So it's really amending the Healthy Workplaces, Healthy Families Act of 2014 by a few different things. It increases an employee's entitlement to paid sick leave from 3 days to 5 days, or from 24 hours to 40 hours. You can do an accrual method or front load. The accrual method is pretty interesting. Employees must accrue 40 hours by their 200th day of employment, in addition to accruing at least 20 hours of PSL by their 120th day of employment. So kind of staggered different date deadlines to make sure that those employees have accrued the time. It's still accruing 1 hour for every 30 hours worked. And then there's an increased annual usage cap from 24 to 40 hours, and an increased accrual cap from 48 hours to 6 days. Senate Bill 700 is expanding California's Fair Employment and Housing Act to protect applicants from discrimination based on prior cannabis use, with certain exceptions. I don't expect a lot of employers to really be impacted by that particular bill, but it's just one to be aware of. Okay, Senate Bill 947 revises the California Consumer Privacy Act with the definition of personal information, including personal information that reveals a customer's citizenship or immigration status. The big one here, though, is Senate Bill 497, also referred to as the Equal Pay and Anti-Retaliation Protection Act. It creates a rebuttable presumption of retaliation if an employee is disciplined or discharged within 90 days of certain protected activities. It makes it easier for employees to establish a prima facie case of retaliation. One to be aware of, guys, because terminations are always at the forefront of every employer's mind and the risks associated with them. In California, you just want to be aware that in certain circumstances, a prima facie rebuttable presumption has now been codified. Senate Bill 476 requires employers to pay food handler employees for the time it takes, as well as the costs associated with obtaining their food handler cards. This is basically California's way of making sure that employers are complying with the health and safety code and that employees are able to get those costs covered so that they can be in compliance. They have to be compensated for the time spent completing the training and testing. So important to know that you're going to be paying employees to take state mandated testing. For better or for worse, it's arguably for the better since they're food handlers. Senate Bill 848 makes it unlawful for employment practice for an employer to refuse to grant or request an eligible employee to take up to 5 days of reproductive loss leave. This is a big one. You know, it's providing additional leave for those who have suffered from or had a failed abortion, failed surrogacy, miscarriage, stillbirth, or unsuccessful assisted reproduction. The 5 days don't need to be taken consecutively. They can be taken throughout the course of a 3-month period after the loss event. The state did put a cap. They said no more than 20 days of leave under this benefit in a year, in one consecutive 12-month period. So just something to be aware of. Senate Bill 933 is it extends California's civil code definition of a privileged communication in a defamation action to cover communications regarding sexual assault, sexual harassment, workplace harassment, or discrimination. The law also permits prevailing defendants in that kind of defamation action to recover attorney's fees, costs, and potentially treble damages, which is 3 times damages if they're successful, as well as punitives. Guys, that's a big hitter. You want to make sure that you know, communications that are related to sexual assault or harassment in the workplace are really well taken care of. Otherwise, you might risk some pretty steep consequences. We're about halfway through California, everybody. Congratulations. Bill 1076 codifies legal precedent banning certain non-compete and non-solicitation agreements that had already been established in California through case law. So this isn't so much a big deal as it's changing the law as it is codifying it and providing a notice requirement. You guys have until February 14th to notify employees of prior non-compete agreements that are now void. I think that's probably sufficient time to get it out to employees. But again, this isn't changing any law, it's just codifying it. Bill 525 amends California Labor Code for healthcare industry minimum wage requirements for nearly all healthcare workers. The law also provides these workers with an independent private right of action to enforce these minimum wage requirements. If you're in the healthcare field and you have questions about this, I encourage you to first go take a look at the healthcare schedule based on the type of facility that you are. And then if you've got more questions related to the minimum wage requirement and your particular facility and how to apply it, you can open up a ticket and we can talk about it. That's just a pretty complex, very niche issue for only specific healthcare providers, depending on the type of healthcare facility. Excuse me. I'm getting over a bout of COVID, guys. So if I have to take a moment and put you on mute so that I don't have a coughing fit in front of all you, that's what I'm doing. The California Department of industrial relations and thresholds for customer software computer software employees has changed. Employers may have to pay overtime to more computer software employees now. The threshold is for employees who earn less than $115,763.35 a year, or $55.58 per hour, or $9,646.96 per month. So if you're in the computer software industry and you have employees that make less than that, you have new obligations as it relates to overtime requirements. We've moved from sunny California across the country to wintry, colder Colorado. And Colorado has done something pretty interesting. They've enacted JAFA, which prohibits employers from requesting or requiring job applicants provide information related to their age, date of birth, dates of attendance at or graduation from educational institutions on initial employment applications. So this doesn't bar you from asking these questions during the interview process, but at the initial onset, when it comes to potential employees filling out applications, you may have to make some modifications to those application forms. It shouldn't be too difficult, though. Bill 23-105 signed, it basically expands the notification requirements for Colorado's Equal Pay for Equal Work Act beyond promotional opportunities. If you've been operating in Colorado, you may have heard about the promotional versus not a promotional job opportunity as a loophole. This is closing that loophole. Boulder County has also adopted a minimum wage ordinance, and here it is. In 2024, January 1st, the minimum wage in Boulder is now $15.69. I think it's interesting to take a look at this schedule overall because, number one, a lot of jurisdictions have moved to a $15 or roughly $15.69 minimum wage. But look at this schedule. By January 1st of 2030, right around the corner, guys, when we think about it, $25 per hour is the new minimum wage, with January 2031 creating an adjustment based on CPI year over year, which can be pretty significant if we look back at kind of what those numbers looked like in the CPI during the last couple of years. It's just something to keep in mind. Pretty interesting to see the trends going this way. Connecticut. Here we go. Only two statutes for Connecticut here. The minimum wage one, which is new increase to $15.69. What did I just say? The new trend. Here it is. As well as expanding workers' compensation coverage for post-traumatic stress injuries to all workers, not just first responders. I think that's probably for the best. But regardless, it's going into effect January 1st. Hawaii passed one bill, 1057, requiring most employers with 50 or more employees to disclose a position's hourly rate or salary range in certain job postings. amending existing equal pay requirements by prohibiting an employer from paying employees in any protected category of the state's employment discrimination statute less than what it pays other employees for substantially similar work. If you have questions, feel free to give me a call. I'd love to talk to somebody who's working in or running a business in Hawaii, Illinois, closer to home. We will be covering Minnesota here as well. And we have some pretty significant updates as recently as yesterday related to laws going into effect there. But before we get there, Illinois is going to require private employers to provide a minimum of 40 hours of annual paid leave for any reason. This is essentially a state mandated PTO statute. But this is not just for sick time, like we've seen in a number of other states over the last couple of years, but this is just pure, unadulterated leave for whatever an employee wants. You can front load if you want on the first day of employment, or you can use an accrual method. Employers may not require any documentation or certification of the need to take the leave, again, because you don't necessarily need to take leave if you want to go on a trip to Tahiti. Employers may require, however, up to 7 days notice if the leave is foreseeable. So you can't, have an employee drop on your doorstep, hey, I'm going to Tahiti tomorrow, because it probably took them a little more than a day to get that trip planned. And you can establish a 7-day notice requirement. There's also a minimum increment of taking the leave of not less than 2 hours per day. The Illinois Department of Labor published FAQs related to the paid leave for all workers. I encourage you to take a look at them if you're going to be operating or have employees operating in Illinois. It answers a lot of questions. If you still have questions, feel free to submit a ticket. Evanston, Illinois adopted a Fair Work Week ordinance expanding the hourly workers' rights to predictable scheduling across multiple industries. If you work in Evanston and you're wondering about whether or not you this applies to you, feel free to reach out and we can talk about it. This is very, very narrow scope, I think, relatively speaking. Illinois Child Extended Bereavement Leave Act. The law requires employers with at least 50 employees to provide between 6 and 12 weeks of unpaid leave, depending on your size, for employees who have lost a child due to suicide or homicide. So if you've got more than 50 employees, it's worth making sure that you are complying with this statute, and really unfortunate if you ever have to give this leave, I gotta say. Chicago City Council has passed a paid leave ordinance requiring all Chicago employers to provide employees with at least 10 paid leave days. The new law alters the existing city sick leave requirements, creating 2 separate categories for required paid time off. It adds a lot of complications for employers with the varying types of leave that will have different rules for initial eligibility, minimum usage, rollover, payout, and payout on termination. So if you're operating within the city of Chicago, you're probably pretty aware of what's going on with the changes and their complications. We're here to help you. if you are wondering how to best implement. Michigan. Michigan has implemented one law this year, and it repealed the state's right to work provisions. It's effective March 30th, not January 1st. So don't freak out on me, Michiganders. It's complicated, guys. It's really has to do with union and non-union employees, and whether or not paying dues is going to result in potential violation of union security clauses. If you don't have any idea what I'm talking about, and you're in Michigan and you work with unions and you're worried about whether or not there is a union security clause, I encourage you to first of all look at those collective bargaining agreements that you've got to see if there are any dormant union security clauses that are going to be going into effect, and then we can talk about what the employer's obligations are as it relates to those clauses and the repeal of the right to work provision in your state. Maryland, the Fair Wage Act of 2023, uniform $15 hourly minimum wage for all employers effective January 1st. This is another state that's jumping on the 15 an hour bandwagon. It's not quite $15 and 69 cents, but it's close. It's close, right? We're 69 cents away. Governor Moore also approved the Maryland General Assembly's modifications to the Maryland Time to Care Act, which among other things established employer and employee shares of the total rate of contribution under the statute. Excuse me, contributions from employees and employers with 15 or more employees will continue to fund the program, while these required contributions were set to begin on October 1st. They've been, of this year, 2023, they've been pushed to October of 2024. This bill, it's Bill 828, for those that are wondering, does not identify the total contribution rate that will apply on October 1st, 2024. So there's a lot of things still up in the air. It's something that's going to be continuously kind of updated through the rest of the coming year. But what should Maryland employers do now? Review and modify the relevant leave policies that you have to reflect the changes in the program, and including the expanded definitions of family members, permitted reasons for taking the leave, and coordination of the program leave benefits with other employer provided paid leave benefits. You should ensure that human resources and payroll personnel, as well as payroll services providers, are aware of the program's implementation delay. You don't want to start contributing before you have to, of course, and continue to monitor the Maryland Department of Labor for the release of relevant information, including the initial contribution rate that will be applied on October 1st of 2024. So it was going to go into effect this year, 23. It's been put on hold. I know this isn't technically a January 1 issue, but it's an important one that I think we needed to address nonetheless. Minnesota, I'm home. We've done a lot in Minnesota over the course of the year, with a lot going into effect on January 1st. Governor Walz signed an omnibus bill that did a lot of things. It banned non-compete agreements that was effective July 1st. But it also creates new paid sick leave entitlements for all employees here in the state. It provides employees with additional pregnancy and nursing accommodation. It prohibits employers from mandating attendance at employer-sponsored meetings about religious or political matters. And it adds protections for employees who disclose their own wages or voluntarily discuss their wages with other employees. The Minnesota Department of Labor also announced a minimum wage increase, adjusted for inflation. It's 2.5%. There's also a minimum wage increase in the city of Minneapolis as well. It is over that $15 mark. The city of Bloomington did myself and all the HR professionals here a service by amending its paid sick leave law to more closely align with the statewide paid sick leave mandate. It will expand the definition of family members, modify the allowable reasons for leave, allow front loading with no waiting period, and allow reasonable documentation to justify the reasons for the leave. Again, this is just coming into compliance with the paid sick leave law that was passed in the omnibus bill on the previous slide. Two things that are very important about the paid sick leave law here in Minnesota. The Minnesota Department of Labor released a new set of FAQs related to the statute. It is very helpful, and I encourage all Minnesota HR professionals to go check it out, all business owners to go check it out. One of the things it talked about specifically that I know we've seen a lot of questions about here in the Compliance Center is proration if you're going to front load. So if you have an employee that joins your company in July of 2024, and you guys have decided that you're going to front load 80 hours for all employees starting January 1st, 2024, well, what do you do with that employee who's starting in July? Does he get a prorated amount? Does he only get 40 hours instead of 80 hours? Can you do that under the statute? And the answer is no, you can't. You have to give that employee that starts on July 1st or on any other day in that year the same amount of front-loaded leave as you would have for that employee on January 1st. However, if you don't like that, if you're nervous about giving an employee that starts on December 1st 80 hours of paid sick and safe time, you can do an accrual method, and then on the following calendar year, grandfather them in or bring them into the other employees' fold that have been grandfathered in with the 80 hours front load. So you would have one employee who started in December accruing 1 hour for every 30 hours worked until January 1st. And then everything would kind of reset and they would be at 80 hours front load. Are we happy with it? Yes, because it answers questions that we had about the statute. Is it maybe the most satisfying for some employers? That's for you to decide, right? But I encourage you to go read the FAQs. They answer a lot of questions that I think we all have. Minnesota also prohibits employment discrimination based on gender identity and prohibits an employer from inquiring into or requiring disclosure of job applicants' pay history during the hiring process. Something to just be aware of when you're looking for new hires. Nevada's OSHA announced an increased penalties that took effect on that will take effect on January 17th and March 24th regarding an updated list of establishments in targeting for programmed inspections. If that means something to you and you want to talk about it more, come my way. Otherwise, kick back. We're going to go through one more Nevada statute and then we're off to New Jersey. Senate Bill 290 in Nevada requires earned wage access providers to obtain a license from the state government and regulates those providers. The law governs entities that provide consumers with an advance of income they have earned or accrued, but have not been paid at the time of the advance. The early wage access, or EWA, grants workers the immediate access to wages that they've already earned before their regular payday. It allows for more flexible cash flow, granting workers access to wages when they need it, and can provide them with more control over their money, which allows them to better respond to unexpected expenses. Right? Why does this matter to employers in Nevada? Well, the argument is that it improves employee retention because it allows these employees to meet the financial needs that they have in between paydays. If you're going to be an EWA provider, you'll be required to obtain a license, like I mentioned, from the Commissioner of Financial Institution via an application form. I don't think we really need to go too much further with this one, other than to say that California is also involved here because California's Department of Financial Protection and Innovation proposed regulations that would consider EWA advancements as loans between the employer and the employee. There's potential crossover with employees from California working in Nevada and vice versa. New Jersey. The New Jersey Department of Labor launched the Wall, and the Wall is basically a heary notice for businesses that are in violation of the state wage benefit and tax laws that are enforced by the agency. It also, if you're put on the wall because of one of those violations, you're prohibited from any public contracting in the state. The message here is don't get your name on the wall. New York. New York has got a lot of activity in the employment sphere as well. Two statutes here that are going into effect. One prohibits employers from requesting or requiring an employee or applicant to disclose access information for personal social media accounts. I think that goes without saying, guys, but here we are. It's a statute. Don't ask your employees for their social media credentials. The other statute requires employers to provide employees with written notice of their right to file for unemployment when they separate. Bill 5295. It renders unenforceable agreements that assign an employee's rights in an invention to their employer, even where the employee develops the invention entirely on their own time without using the employer's property. This will have an impact on any IP agreements or intellectual property agreements that you have or that you have employees sign looking forward January 1st on. Bill 5572 increases the salary threshold for certain wage payment exemptions, such as pay frequency requirements. It's again, it's very dependent on the type of employee that you have, and the salaries that they're making. So if you're interested in digging a little deeper, of course we can, but I encourage you to look at those schedules first. New York's paid family leave program is updated for 2024. The employee's maximum benefit is now $1,151.16. That's an increase from 2023. And the annual contribution by the employee is now reduced from 2023 by $66.18 to a total of $333.25. Additionally, the list of family members who are eligible workers who can take paid family leave to care for was expanded in 2023 to include biological, adopted, step, and half siblings, including those living outside of New York and the United States. So the pool for potential persons that could allow for an employee to take this leave has just increased, and I would say that's quite dramatic. Going from not just those living outside of New York, but those living outside of the United States is pretty big, pretty far-reaching. Ohio. The city of Columbus joins Toledo and Cincinnati as one of the latest cities to prohibit employers from asking prospective employees about past compensation. It's effective March 1st. Employers operating in Columbus may not ask about wage or salary history. It marks it as an unlawful discriminatory practice for an employer to ask about the applicant's salary history. Couple jurisdictions there in Ohio that are doing this now, so it's not exactly new in the state, but it is new to the city of Columbus. The other thing Ohio did this year that is a pretty big deal is it joined Minnesota and 22 other states in passing a recreational marijuana law, legalizing and regulating the cultivation, sale, possession, purchase, and use of home growth recreational marijuana. The thing about this one, though, that's interesting, some other states do this as well. Minnesota is kind of on the fence about it and how it addresses the issue. So the law does not require an employer to accommodate an employee's use, possession, or distribution of adult use cannabis. When I speak to Minnesota, what I mean by that is there are the law does not allow for the use, possession, consumption, or distribution of cannabis, drugs, or alcohol in the employment space at work. But there are some changes to Minnesota's drug and alcohol testing statute based on whether or not an employee can be tested and at what times for cannabis, depending on that employee's description under the and whether or not they qualify as a safety sensitive position. So Minnesota, again, employees are not allowed to be under the influence or be in possession of drugs, alcohol, or cannabis. Here, the law is pretty much the same. An employer doesn't have to allow an employee to be under the influence of cannabis or be in possession of cannabis at work. It's just an important thing to note there, right? If an employee can go home and get high, but they just can't bring it to work with them. They can't do it at work. They can't do it on their breaks. If you've got questions about how Ohio is implementing the recreational adult use cannabis legislation, feel free to reach out and we can talk about it. Oregon House Bill 3307. It extends civil rights, discrimination, harassment, and workplace protections to participants in registered apprenticeship programs and certain private sector on-the-job training programs. House Bill 3443 expands the eligibility for protected leave under the Oregon Family Leave Act to include bias crime victims. That's just going to be a modification to your Oregon family leave policy, if you have one, if you're in Oregon. 1033, it changes the definition of active service of the state for purposes of the requirements that an employer grant a leave of absence during a period of active military service. And 907 bars employers from retaliating or discriminating against employees who refuse to work that would expose them to serious hazards, provided that the employee acted in good faith and with no reasonable alternative, right? The question of what is good faith and whether there was a reasonable alternative are going to be things that are determined by case law. So it's very much fact-specific determinations when looking at whether or not an employee's refusal to do work qualifies under this new statute. Rhode Island. The governor signed a bill that increases the penalties for employers that knowingly and willfully violate the wage and hour laws and specified additional penalties for employers in the construction industry. This is just to say, wage and hour violations can result in some pretty significant penalties to employers across the country. Rhode Island is not special in this sense. It's new. It's going into effect in January of 2024. But if you're worried about whether or not you're violating wage and hour laws, and it's something that you haven't addressed yet, I encourage you to address it sooner rather than later. Those problems can snowball and balloon quite quickly, and as you can see, the penalties continue just to get steeper and steeper. Very rarely do state legislatures go, oh, we're gonna walk back our penalties for violating a wage and hour statute. Tennessee has enacted the Paid Family Leave Insurance Act, which authorizes the issuance of an insurance policy that an employer may offer to an employee for the purpose of providing family leave benefits. If you're in Tennessee, it's an option for you to provide to your employees. Obviously, things like this cost money for employers, but at the end of the day, providing benefits attracts new and better staff. It also does a really good job at maintaining the current staff that you have, right? It keeps retention up, and things like that are important, especially in a tight labor market. Washington State. Senate Bill 5111 amends the minimum wage law and requires employers to pay out standalone unused paid sick and safe time to certain short-term or temporary construction workers. It's limited to the construction field, so it's not broad sweeping, but it's still important to be aware of if you're in construction in the state of Washington. Senate Bill 5123 will prohibit employers from making hiring decisions based on off-duty cannabis use or a positive pre-employment drug test detecting non-psychoactive cannabis metabolites. This is all to say the question of how to enforce or address cannabis consumption outside of the workplace and its impact on employees is an ongoing process nationally. I anticipate things to be consistently fluid for the foreseeable future, which is why if you operate in a state that has legal recreational cannabis, it's not said and done, right? There are going to be changes to how cannabis is viewed and addressed in the workplace and in the hiring environment. And you want to be aware of those changes because it can result in potential discrimination claims if you're not in compliance. Senate Bill 5586 allows employees and employers and third parties acting on behalf of an employer or employer to request access to records related to paid family and medical leave claims. The Washington Department of Labor and Industries announced an increase to state and local minimum wage and exempt salary thresholds for 2024. If you have employees in the state of Washington who are 14 or 15 years of age, they must earn at least $13.84 an hour in 24. The minimum wage rate is currently $15.74 per hour for employees aged 16 and older. Again, that $13 pay scale is only for 14 and 15-year-old employees. Once they jump to 16, their minimum wage pay goes up pretty significantly. So we've just covered a lot of law across a lot of jurisdictions, some local, a lot of them obviously state. And you're probably wondering if you're operating in a handful of jurisdictions, or how do we comply with all these laws? Well, there are a couple steps. First, you got to understand what those laws are and where they're most likely to vary. California, for example, is in stark contrast to a state like Tennessee. And then you have to think about how you want to apply those policies and your method for tracking them. And then also you want to have a method for tracking where your employees are working. Because if you don't know where your employees are working, you may be running afoul of that state's legal requirements. But here's the most important thing. The most important thing is you have to choose your approach. There are two ways to do it. If you work in multiple jurisdictions, or if you have employees that work in multiple jurisdictions, you can either look to whatever the most friendly policies are or requirements are across all those jurisdictions and compile them together and create the most employee-friendly policy that just is blanket for all employees, regardless of where they're working, or you can maintain separate policies for each jurisdiction, right? Both of these have costs. The first one, which is the most employee-friendly, can do a lot towards making you a very employee-friendly company where people want to come work for you and things like that. But it can also create a lot of expense for a company where you otherwise might not need it because the jurisdiction that some of your employees are working in is not requiring that much contribution by you as an employer. Separately, though, right, if you put in place a separate policy for each of the jurisdictions you operate in, you're creating a potential administrative nightmare for yourself where you're going to be spending more time and money on ensuring that you're maintaining these separate policies and implementing these separate policies effectively. Where with the other one, right, it's one and done, easy. You also want to make sure you spend time preparing for January 1st and July 1st. Those are the two dates every year where most laws go into effect. Like I said, there were some statutes here that were going into effect sometime in the first quarter. Again, and there are some statutes that, are going into effect in October of next year. Those are the outliers. It's typically January 1st and July 1st. But to become in compliance, it's not just a one-day thing, right? It takes a couple days, it takes a couple weeks most time to make sure that your policies are up to date, that you have time to talk to us about it, and then roll it out to your employees and address any questions they may have before things get rocking and rolling. And then, of course, it's really important that you have a trusted payroll provider. That can go a long way towards making sure that you're complying with statutory notice requirements on pay stubs, that you're accurately collecting the hourly information or accrual information for different benefits for employees, wherever they may be. So, as far as questions are concerned, we're right up at the butt end of our time together. It's been an hour. It's been a whirlwind. I appreciate you all sitting through this with me. If you operate in all of those states, you've got a lot to cover. If you operate in a handful of them, it maybe is a little bit easier. And if you only operate in one or two, I think you're probably pretty well set for whatever's coming at you in January. If you do have questions, though, if you do want to find out more about any of these statutes, or you want to make sure that your policies are in compliance, submit a ticket to our compliance center, and myself or another member of our team will be there to help you out. Thank you all so much.